And first and foremost, I think we should define what we're going to talk about here. So, civil procedure is about the body of law that regulates civil cases. So we're not talking about criminal things, but civil things. And that can be brought about on many different grounds, such as breach of contract or divorce proceedings, personal injury, many different possibilities here. And the ability to be subject to civil proceedings is called cognizability, which means that if something is cognizable, then it can be brought before court. So I don't know, for example, not saying hello to someone would not be considered cognizable, even if you're offended by that. So you would not be able to get court relief in that situation, for example. In short, the entire process constitutes of a plaintiff and a defendant. The plaintiff files a complaint against the defendant, who files an answer, and thereafter the judge schedules a time and a date for proceedings and other important details. And the parties appear before court and they engage in so-called discovery, which is the exchange of information. And then the jury or judge comes to a decision which either party can appeal if they're not satisfied. Appealing means putting the matter into the hands of a higher ranked court to review everything again. And of like most parts of American law, you have always this concurrence of the state and the federal level. Thanks to the Constitution, each state has the possibility to also exact civil litigation. So yeah, they exist concurrently, and there are times when one is preferred over the other, and that's what I'll be talking about in my part of the presentation. When a federal court will deal with a specific case, a civil case, and when it has to be reduced to the state level. And in general, there are three things for a court that a court needs to hear a specific case. Those being personal jurisdiction, subject matter jurisdiction, and a venue. And although I will mainly focus on personal jurisdiction and subject matter jurisdiction, venue is essentially just a geographical location within the judicial district that gets determined based on, most of the time, the defendant's residence. But the other two requirements, personal jurisdiction and subject matter jurisdiction, require more detail, more explaining, which is what I'm going to start with right now. Okay, so let's start with subject matter jurisdiction. It is the authority of a court to decide a specific case. What's very important here is the distinction between federal courts and state courts, because state courts are usually allowed to hear any type of case. So the question of subject matter jurisdiction only really arises when it comes to federal courts. And why does this exist? Because federal courts are just more formal, they're more, also, the whole process is just more arduous than with state courts, so that's why it would just be ridiculous for the federal court to hear every single case that exists under the sun. That's why this distinction exists, in order to create some kind of requirements for a case to even be heard by on a federal level. Article 3, Section 2 of the Constitution defines the requirements needed for a federal court to have subject matter jurisdiction, and they can be broken down into the following points. You have federal question jurisdiction, diversity jurisdiction, supplemental jurisdiction, and removal. I'm going to start with federal question jurisdiction. So if the plaintiff alleges a claim that arises under federal law, the federal court has federal question jurisdiction and can therefore hear the case. What does that mean? A claim that arises under federal law. That can mean there can be anything that arises from the U.S. Constitution or a federal statute, or very commonly copyright infringement claims they arise under federal law. And what's important here is what the plaintiff alleges. It doesn't matter if the defendant legislature under the Constitution, or yeah, on a federal level, basically. Then we have diversity jurisdiction. Itself has two different requirements. If both of them are met, then diversity jurisdiction exists. Therefore, and then the federal court can hear it. What we need here is complete diversity of citizenship. So I'll explain what that means later. But the general rule is if every citizenship is different on the plaintiff side. From the defendant side, you have diversity jurisdiction. So very simple example, the plaintiff is from New York and the defendant is from Texas, then you have a very simple case of diversity, complete diversity. Of course, it gets more complicated if there's more than one party, but what just matters is that everyone on the plaintiff side, the citizenship is different than everyone on the defendant side. But of course, the question is, what is citizenship? I mean, it's not defined. It's not citizenship in the way we think of it as being a citizen of a country. For individuals, not countries, for individuals, your citizenship is basically where you are domiciled, where you live, and where you plan to stay there indefinitely. And every person can only have one domicile. There's no way to have two citizenships. The exception to that being companies. They have two. They have, one of them is where the company's headquarters are, and the second one is where they first filed their articles of incorporation. Those are files that document the creation of some kind of company. So in that case, of course, you would have to see if that company's two citizenships are different from the defendant or the plaintiff, depending on what side we're talking about, and then you would have that. But complete diversity won't really help you. It's not enough. You also need a specific amount in controversy. It has to be over $75,000. This is also pretty straightforward, but you may ask yourself, okay, what if the plaintiff has different claims, each of them being less than 75,000, but if you add them up, they are over, over 75,000. So for example, he has a claim for 50,000 and one for 30,000. Well, then it's no problem. You can just add them together. The only time when you can't add them together is when there are two plaintiffs filing a claim, each amount lower than 75,000. So if it's the same plaintiff, the claims can be added together, but if it's two different plaintiffs against the same defendant, you will not add them together. The next way for a federal court to have subject matter jurisdiction is supplemental jurisdiction. So if federal question jurisdiction or diversity jurisdiction, so the two types that I was talking about earlier, have already been established for one claim, then another claim that doesn't meet those two requirements can be heard by the federal court. If both claims constitute the same case or controversy. That means that if you have two claims and one of them meets either the requirements of federal question jurisdiction or diversity jurisdiction, but the second does not, but they're somehow intertwined through the same case, the same contract, same transaction, then they both can be heard before a federal court. Here's an example. A person hires a guy or a girl to write a book for her, and of course he also wants the person also wants the rights to the book. And if the person, the author of the book, takes the book for themselves and also uses it for themselves, then we have two breaches here. We have a copyright infringement breach because, of course, the person wanted the book written and, of course, wanted the rights to it. And like I said before, copyright infringement is usually a federal thing. And we also have a just normal breach of contract because the person ran off with the book. That breach of contract would usually not constitute a federal case, but since the copyright infringement claim would fall under a federal issue, the second one can also be heard in front of a federal court. That's a perfect example of supplemental jurisdiction. The final way in which a federal court can have subject matter jurisdiction is removal. That just means that you remove a case from a state court to a federal court. And when does this happen? It happens when a plaintiff could bring a case into into the federal court, but decides to leave it at a state court. And the defendant says, no, I want that. I actually want it to be heard before federal court. So that means that the requirements are there. It's just that it was just a plaintiff's conscious decision to have it heard before state court, and the defendant can, in that case, say, no, let's not do that. There's one exception to that rule, though. There can be no removal to a federal court if the claim is being heard in a state court of which the defendant is a citizen. And this rule is kind of straightforward because why would the defendant want to move the case to a federal court if it's already being heard in the state where he is domiciled, where usually you want the laws to apply where you're from because they're the ones you know best. So that's pretty much. The second thing that you need for a case to be heard, for a case to be decided, is personal jurisdiction, which is the authority to adjudicate the rights and liabilities of the defendant. And that can just be done. You can't just adjudicate a random person in some random area if he has no contact to that area. So an example, if I have never been to, I don't know, Alaska, never made a phone call there, never lived there, then I can't be, summoned to court in Alaska because there needs to be some kind of minimum contact to that state. But there are, of course, requirements here as well. And it's very simple. There are these traditional bases that I already talked about before. I already talked about domicile. So of course, where a place where a person lives and plans to stay indefinitely is a place where he can obviously also be sued. We also have the physical presence clause, which means that if, it's actually very interesting, if someone is physically present in the state where the claim got brought to voluntarily, and they receive notice of the lawsuit in that state, then they have physical presence. So that means that you can, let's say I'm in New York, I go to Florida for a second, even for just an hour, and I receive notice of a claim that was made in Florida, and then it is possible for me to get sued there, even though that could have been my first time there. The only important thing is that it was lured there voluntarily. So the plaintiff can't just lure the defendant on some kind of false pretenses. As long as the person goes there voluntarily and receives notice of some kind of claim while being there, then they can be sued there as well. Consent is also a thing. Of course, if one person consents to have the case be heard in front of some kind of court, then if he wants that, then of course there's no problem, right? But that won't usually occur if the court is someplace that he's never been to, state that he doesn't know, because state laws can vary greatly within each other. Final thing we have to talk about here is the waiver. If the defendant wishes to not have personal jurisdiction over him, he must object and explicitly say so. If he does this objection too late, and the defendant already started to participate in the case, and shown up in court and everything, then he has basically waived his right to object, and then he will have to continue going to court and pursuing the case in that area, even if he decides later on that he doesn't want to. So there's a specific time grace period for the objection to be made. And if none of the traditional cases are satisfied, so if none of those four things apply, then there's something called the state long arm, which is a situation where, despite not living there, despite not having any physical presence there, a person can be sued in a specific state. This clause also has three different types. The first one I want to talk about is general jurisdiction, which is when a person has very continuous and very systematic contact with some kind of state. So let's say a company produces paper and is based in California, but it also has a manufacturing facility in Washington. Then even though it's based in California and it obviously has to travel to California very often, then you would consider that some kind of very continuous and systematic contact, which is why a claim can be brought forth in both Washington and California in that case. And we also have specific jurisdiction, and this is when a case can only be, there is also contact with some kind of state, but the claim has to be related to the contact. So the paper company has to go to Arizona, where a place where they usually don't go, for some kind of part in producing paper, and they run someone over or they rear-end a driver, and they can get sued in Arizona because it arises from this reason that they were there. Okay, when it was to fulfill their business purpose. If they were just there, happened to be there for non-business reasons, then that wouldn't work. But in that case, you would say yes to a specific jurisdiction, and those are all examples of a state law. I will now give the floor to Marie, and she will